Welcome. Friday workplace briefing, and once again it's me alone. I've actually got a couple of dogs wandering around here. We might see them, but we won't see Kim, we won't see Nina, and we won't see Moon. So this week on the Friday workplace briefing, our focus is going to be on when is a resignation not a resignation. And that's a case we're going to discuss towards the end, and we've got a case study that's on it. But let's now move on to the latest news. We've got a whole lot of stuff that's happening at the moment. We've got some great cases to come and a little bit of new legislation that's on its way. But I want to move on to our first case, which is about bullying. This is a case of Miss Kaur. She was a nurse at a Bupa hospital, or a state enrolled nurse at a Bupa hospital, and she had concerns about staffing numbers. Now, she raised that with Miss Joy, who was a senior nurse. And Miss Joy said, was alleged to have said, why don't you just get on to work on the ward? Don't you worry about staffing numbers. There's a proper way to do things. But she felt this pressure that related to staffing numbers. And she agitated that as an issue for her and for other people. Ultimately, she was placed on paid leave in respect of an investigation and conduct. And she felt stress that came about as a result of being placed on paid leave, or what people commonly call being stood down. So the real question here, and this was an anti-bullying order that was sought, was the nature of the conduct by Bupa bullying. Now, it's really interesting, isn't it? Because psychological hazards as a concept doesn't exist inside of the Fair Work Act. It exists under safety law. So this is a Fair Work Act stop bullying order. Bullying is repeated acts which are unreasonable and they hurt, harm, or humiliate and make a workplace unsafe. So what did the Fair Work Commission find? Well, the Fair Work Commission found there was no bullying because it wasn't repeated and it wasn't in the circumstance unreasonable. And I want you to understand that the test for what is bullying, what hurts, harms, humiliates, or intimidates, is incredibly high. So what occurred here was a series of actions that had been taken, but they didn't equal bullying. Now, had they reached that level, but it was reasonable management action when looked at what was occurring, in other words, it was repeated actions, it did harm her and it did make her work unsafe, but it was reasonable what was occurring, that would be a complete defence. But you didn't need to get that far because it wasn't unreasonable. But that's not where it ends, and I think that's the really important part of this story. The court were highly critical of Bupa's behaviour. They recognised the manner in which she was treated was not good, and in terms of a psychological impact, was obvious. So I'm using this case really just to show, the bullying applications are rarely made. They're rarely successful when they are made. There are very few hearings in a year. It's one of the most underutilised parts of the Fair Work Act. But it does remind us when we use this expression bullying, it is colloquial and overwhelmingly misused. It is a high standard, but misconduct is still misconduct. Misconduct that causes psychological harm is a psychological hazard. Miss Kaur would never have succeeded with the support of WorkSafe for a prosecution, but it's quite possible that if WorkSafe had have attended, they may have issued an entry notice or issued a requirement of a notice of improvement based on the conduct of Bupa prior to her bullying application. So I reckon that's an interesting case. Not a lot of great law in it, but really illustrative of where the law is going. I want to talk to you about repudiation. So let's look at the next case around repudiation. This is the OSM Australia case, and it is a fascinating case. This was a woman who, prior to parental leave, went from being in an operations manager role into a project management role. When she returned from parental leave, she was then put in a workforce planning role. That was done for no reason that related to her parental leave. Okay, pretty important thing to remember. While she was an operations manager over a significant period of time, she had an entitlement to receive a short-term incentive. She raised this persistently with OSM on her return and saying, look, am I going to get paid my short-term incentive? You've moved my position, but my role is and has been an operations manager role. What's happening about it? Silence. She eventually got a response and said, got a lawyers to write and said, look, you've got to pay the short-term incentive and you've got to return it to operations role. And if you don't, we'll accept that as repudiation. So what does repudiation mean? Repudiation is an act by a person in an employment relation, either employer or employer, which fundamentally breaches the contract of employment. To rely upon that, the other person, in this case the employee, must accept that repudiation. So therefore, it becomes, in this case, a termination at the will of the employer because you've accepted the wrongdoing of the employer. Now, I had a bit of a chuckle in some parts because the Commissioner was a bit critical of the original legal advice, saying you're walking a tightrope doing this. Can I just say this is LAW law? There's nothing new or mysterious about this. This wasn't high risk. Once you can establish that the bonus was a fundamental part of the contract, then the failure to pay it is unquestionably a repudiation, and it was a significant part of the remuneration. But the argument here for OSM was, well, it was an entirely discretionary payment. We had a choice to make it or not make it. She knew that. But over a period of a significant number of years, she had enjoyed the benefit of that and came to rely upon it. So although the legal analysis in this case is poor and very loose, there is little doubt at all that that became a term of the contract through practice. Okay, so it ceased to be just something that was permissory or discretionary, and it became an expectation which it would be wrong or unjust to say was no longer there. So whether it was contractual or what's called an estoppel, it doesn't really matter. It unquestionably goes to the heart of the contract, and the failure to pay led to repudiation. Therefore, she was right to accept that repudiation. And this was a decision about jurisdiction, because this was a general protections claim about mistreatment for about her pregnancy and the repudiation. And the court held unquestionably this was a termination by the employer and therefore had the jurisdiction of the Fair Work Act. So I think a really good case. Can I just say, repudiation is an argument that's underused. I have no criticism of the lawyer doing what they did. It brought it to a head. And yes, there was some risk with it, but the evidence was relatively clear that it was repudiatory and it was proper to accept it. The question is, what would happen if she said, look, it's a repudiation, and then she took, I don't think it's fair, and they started having an argument about it, and she got paid 3 more times, and she didn't act upon it, and then she eventually acted upon it. The acceptance of wages after the date of repudiation, particularly on a couple of occasions, would amount to what is called a waiver, or a view that you do not say it is repudiatory or rely upon the repudiation, and therefore her claim for jurisdiction would have failed. All right, complex case, but interesting, and I think a great case and one we can all learn from. What I want to go on and talk about briefly is the new federal legislation to ensure gender equality. Interesting piece of legislation, federal government piece of legislation. It's really looking for businesses with over a 500 people headcount, and the purpose is to ensure that there is gender equity in participation and payment. It's transitionary in nature. In other words, you don't have to get it right first year, but you have to demonstrate a pathway to getting there. The likelihood of this getting through Parliament is very, very high. So we'll let you know when it actually passes the final reading speech and gets approval from the Governor-General, and we'll talk to you more detail about what it means at that time. But for the moment, likely to get through. It's part of a series of pieces of legislation by the federal Labor government seeking gender equality, and I don't think it's likely to be reversed. Now, we're going at a bit of speed here because I have actually nobody else to talk to disagree with me. Normally Nina would be chastising me at this stage, but she's not. Moon would be answering questions for me, and Kim would be giving me that look like I know nothing. I'm just going to motor ahead. So why don't we look at the tree management case? Classic safety law case. I think, again, if we can just go to that heading, which is the high-risk injury case, this is a case that dealt with a caravan park, which was the Yarra Valley Park Lane Holiday Park. The caravan park had a number of trees. It hadn't done a review of the tree's safety since 2015. One of the branches of a particular tree fell on a person who was staying at the caravan park in a tent, and they died. The caravan park was fined $475,000. But the issue that came out of this, and again, You notice the cases here are just illustrations. There's no magic law in this. What it is showing you is death by breach of system. The tariff is going up. So, it would have been 350 to 380 for low-level systems breach 7 or 8 years ago. We're now looking at $450 to $500,000 for death where there was a systems breach. What were the systems breach here? There was no proper system for managing the safety of trees. There had been no recent audits done. When WorkSafe attended, they found multiple trees that were high risk. So it's not surprising of the sentence that was given. And I just think we need to take that back as we look at our day-to-day operations. And we need to go, look, what are the high risks in our business? How are they going to impact us? What are we doing about those high risks? Do we have a system? Do we identify those particular risks? Do we have controls that are in place? Do we ensure those controls are being executed? This is a case where they didn't do that. They just let it run because, like many people who become desensitized to risk, they walk past the tree and say, that didn't fall off today, that seems safe. And after a while, they forget trees are dangerous. Like farmers forget tractors are dangerous. Like people who do roadworks forget plant and equipment, mobile plant is dangerous. Like warehouses forget forklifts are dangerous. We could go on. But my point is, just because it hasn't killed or injured anyone in the last 10 years doesn't mean it won't happen tomorrow. And that's what WorkSafe thinks, and that's also what the courts think. Okay, let's have a look at our next case. Now, our next case is a bit of an illustration. As I said, this week is not about new law, but it's an illustration about the difference between the common law and safety legislation. So this is a case, Pterococcus and Allen's Foundry, where a guy was climbing down a ladder and fell, and the ladder was a vertical ladder. And his argument in the common law damages claims, or not his argument, but yes, it was his argument in the common law damages claim was, well, look, the manner in which the ladder was vertically placed, the lack of training, all meant that it was entirely the Foundry's fault for him falling. But there was evidence that the manner in which he climbed down was unsafe. He didn't have both his hands on. Everyone understands the 3 points of contact rule. And at first decision, he was found to be 65% responsible for his own. So that means out of whatever money he got, he only received 35% of that, because that was the level of responsibility of the business. Now, nothing turns much on that, does it? But in safety law, both the Foundry and he could be fully liable. Okay, they could be fully liable for the entire penalties that exist. But in safety law, the likelihood of him being prosecuted was zero. But the likelihood of the Foundry being prosecuted was very high. So under safety law, it's very likely that the Foundry would have been prosecuted and the employee would not have been. But at common law, yes, the worker brought the claim against the Foundry, but he was found 65% responsible and therefore only received a small amount of the money. By going to appeal and the costs associated with appeal, I think this poor character probably ended up with very little at all, if not owing money, because the appeal court totally agreed with the trial judge. Psychological hazards and physical hazards and what happens to them. Let's look at this New South Wales police case, the next case on our list, where a police officer died, and he died of what's called Barrett's esophagus cancer, and Barrett's esophagus cancer arises from repeated exposure to stomach acid. The argument of the family, because this was a claim by the family, a dependency claim, was that his exposure to thousands of traumatic incidents over 16 years of service led to him drinking excessively, a bottle of bourbon a day, and smoking heavily, and that increased the stomach acid and the volatility of his stomach acid, leading to the cancer. And that causal link was substantiated by medical evidence. And as a result of that, so it starts off with psychological hazards. By 2019, he was suffering from post-traumatic stress disorder as a result of his response to his post-traumatic stress disorder of alcohol and cigarettes. He suffered cancer and he died. And the dependency claim was accepted because it related to workplace stress. So a fascinating case, isn't it? Because here you've got a psychological hazard that causes a psychological injury, and the psychological injury leads to alcohol abuse and cigarettes, which leads to a physiological phenomena of heightened stomach acid, which leads to a cancer. Therefore, the family are entitled to succeed on their dependency claim. I think what is the lesson out of that case? And I think this is a really good lesson, particularly when we look at frontline service people like police, firemen, AMBOs and the like, is when you're looking at really high risk work that's being undertaken, which is traumatic in its nature, some actual, some vicarious. And we know there's already cases based on the coroner's court case, a classic example of a case that deals with psychological hazards from vicarious trauma. The repeated exposure to sexual assault, those types of issues, can have a significant impact on someone. So we know this is a really high risk in a number of industries. And when we know it's a really high risk, yet we allow it to continue without appropriate intervention to the stage that someone suffers post-traumatic stress disorder, what happens next, we have no control of. And if that leads to a serious physiological injury or illness and then to death, it's likely there will be liability for that as well. So I guess, once again, we come back looking at those high order risks. We know what this high order risk is. We know we have to intervene. We know that intervention has to prevent psychological injury. But what this case says is once you have that psychological injury, the person's response to that psychological injury to take away the pain from it, even if the response is not a rational response, excessive alcohol and cigarettes, if they do that and it leads to a physiological injury or illness, then it will be compensable. So I think a really interesting, a great case, really well argued case, and a very good judgment. So fascinating case. Why don't we shift on to our next case? And this is really the main topic for today, okay? And this is, when is a resignation not a resignation? Now, this was the CEO of Tabcorp. So this huge publicly listed organisation. He was alleged to have said something, and can I say what he was alleged to have said, to the extent that it's available, was a fairly low level, but it was inappropriate comment in respect of a woman who is part of the regulator, the gambling regulator. Tabcorp undertook an investigation and satisfied itself that he said these things. At no stage was he part of that investigation. He received an email requiring him to attend a meeting, which he attended and found 3 directors sitting in front of him. At the same time, the lawyers for the business were sitting in another room. He was told that. It was made clear to him that he had a very limited period of time, only hours, to make a decision as to what he was going to do. He inquired into the possibility of apologies. He said he didn't think he said it. It doesn't sound like him. He inquired about resignation, and they said, well, if you don't do it by 3 o'clock, we're going to terminate you by 4 o'clock. So he resigned. Now, that's a very short version of everything that occurred. But the argument here, again, is a jurisdictional argument, which is, did he resign and therefore was a termination at his will and therefore not covered by the Fair Work Act? Or was this a termination that he had no other choice whatsoever to resign and therefore was a termination by the company? And what the court held in these circumstances was a termination by the company. And it said that because the description of why Tabcorp did it, that it was protecting its values and had reporting obligations and required urgency, was held to be the nonsense that it absolutely was. This was a deliberate ploy of placing pressure to get a particular outcome, leading to termination of this employee, and therefore it was unquestionably constructive dismissal. But for the main topic, what we're talking about is, well, when does somebody resign? Is it a resignation? We've already had one case today, haven't we? We've already had the case of the person who resigned, and they resigned because their contract, well, didn't actually resign, that's not quite right. They accepted their termination of employment and left their employment, okay? Because that was repudiation. They accepted repudiation. Here's a different thing. So it's not a repudiation, but people are placed in a choice where there is no other reasonable choice available to them. And this happens more often than you'd understand, but it particularly happens in flawed investigative processes like this, or where a predetermination has been made about getting someone out of the business. And there's that informal discussion that says, look, reached the view that this is the misconduct or these are the performance issues. They're very serious issues to us. We're left with very little choice where to go. But there is a face-saving choice for you. There's one that protects your reputation and also the organisation. If you do that, we'll enter into a non-disclosure document and everything will be rosy and you'll be paid out all your entitlements. Even in this case, they weren't clear, deliberately unclear about what would happen if his employment was terminated in relation to a whole series of entitlements. There was enormous pressure sitting on this CEO to make a decision that protected his financial future and his personal brand. Again, why am I raising these cases with you? Because it is so common for us to have these conversations. I'm unhappy with your conduct. I'm unhappy with your performance. I don't want to take you down the hard route. I don't want to manage your performance. You know, at the end of the day, on the evidence that we hold, it's likely we're going to terminate your employment. Please don't force me to do that. There's choices that you can make. That is constructive dismissal any day of the week. So, interesting case, isn't it? Strange that such a large organisation who actually engaged two sets of lawyers to actually achieve this flawed outcome and didn't even speak to their in-house counsel would muck it up so badly. But it is a good lesson for us all because what they did was a level above the usual constructive dismissal. It was, well, it was on any basis, and if you read what the Commissioner says, outrageous and done for a very clear purpose. But less than that is still constructive dismissal. Okay? Why don't we now look at the case study for the day? Nancy was an operations manager and was well regarded within her company, Stackpack, a cardboard and paper manufacturer. Over the last 12 years, Nancy, like other senior managers, received a short-term incentive for production and waste control. Each time it was paid, it was made clear that it was entirely discretionary and not included in her contract. The formula for the STI was essentially the same each year and was discussed at the quarterly budget meetings to encourage performance. In other words, throughout a year, they kept benchmarking how a person was going to let them know, you're on track for your STI. Let's have the next part. Operations managers relied on the STI to earn a significant portion of their income. It was often over $100,000, which made their paltry take-home wage of $165,000 more attractive. Competitors paid low $200,000 range, so above that. So Nancy's high performance over the last 12 years had kept her ahead of the competition. When she was considering to leave and to work at Opal in New Zealand at the end of the financial year, Goran, the CEO, called her and said that 24-25 would be a big year and she could easily earn a total remuneration of $300,000. The conversation took place in May 2024 and Nancy decided to decline the offer from Opal, relying on what Goran had said. In the 2023-24 financial year, based on previous years, she would have been entitled to $120,000 in STI. The STI was typically awarded 2 clear months after the sign-off of the June 30 accounts. That was usually in mid-October. On October 2, 2024, the CEO held a town hall meeting of all senior managers across Australia via Teams. He explained that orders had been down over the last 6 months, interest rates had risen, and to prevent lines closing, there would need to be some budgetary cuts. He identified the STIs as an issue that was under consideration for review. Nancy was a single mother with 2 children in private school. She had relied on the bonus and knew what she could expect to get based on her last quarterly review. She wrote to Goran asking him to guarantee her STI. He responded stating there will be no special treatment. Nancy began to get stressed. Her hair started to fall out, she couldn't sleep, and she required medication for anxiety. She wrote again to Goran explaining the impact on her, but he sent a brief, sharp note telling her that it was entirely discretionary and that she should stop being so melodramatic. 2 days later, the National Head of Operations visited Nancy for a health check and suggested she step down to a lower role until she felt more comfortable. He also informed her there would be no STI. Nancy sent a letter from her lawyer late that night accepting the refusal of the STI and suggestion of demotion as a repudiation and stated that she would not be returning to work. So the questions are, is there a safety issue and who could be liable and what for? Well, were there any psychological hazards? Well, there was certainly a lack of clarity and certainty. There was a change in the reward and recognition. There was some conduct of Goran that was unhelpful and destructive. And there was the final behaviour around the demotion and the refusal. So unquestionably, there were psychological hazards. They are aggregational. They all come together. They were quite profound. And although it is unlikely that a regulator like WorkSafe would prosecute, they could, and if they did, they could prosecute Goran and the company for it. The likelihood of prosecution, less than 5%. The second question is, could she have successfully brought a workers' compensation claim, particularly prior to the termination? And the answer is, it would be a lay down misere. She could not fail it. None of this was good performance management of any sort. The test is her subjective experience of the stresses that were placed upon her. The claim would have been accepted. Number 3, is there a discrimination claim? Well, what do you think? She's put on notice that it's affecting her and it's damaging her, and their action was to seek to step her down to a lower role. So a substantial part of the decision that was made related to the protected attribute of her psychological health. So I think, yeah, there's a good discrimination claim. Next question, was the STI an implied term or contract, or based on estoppel, or an actual fact? Was it an actual term through conduct? The answer sort of doesn't matter. An implied term goes without saying. The fact is that over a 12-year period, it had regularly been paid. It had a method of calculation. People had been taught to rely upon it. So it's more likely an actual term of the contract. It certainly could be an implied term. And if all else fails, it would be unjust to deny that entitlement under estoppel. So yes, it is something that's actionable, and it is something that would entitle you to say, my claim is, my employment has been repudiated and I accept it. Let's go to the next one. Did she resign, or was she right to allege they repudiated the contract? And we've answered that, haven't we? That the action that they did, the demotion that related to a protected attribute, and the failure to pay the STI, irrespective of it being called discretionary, based on the conduct and the manner in which it was relied upon throughout the year and over many years, means it was an express term of the contract, I believe, but if not sufficiently a term of the contract that it goes to the very heart of it, therefore is repudiatory in nature, and yes, she was safe in accepting it. Where would she bring her claim, and what would it be? Well, in the Fair Work Commission, she'd have a general protections claim, wouldn't she? And it'd be very, very easy to prove the general protections claim. So there's a tick there. There's a workplace right, there's safety, there is her state of health, so that's good. Common law courts for repudiation, yeah, I mean, there's a breach of claim. The repudiation has a different damages element because it has not only the actual damage suffered, so what is the lost earning now, what loss has been suffered as a result of it. It has general damages, which is for pain, suffering, and loss of identity. A claim like this would be well over $100,000. But it also has special damages, which look towards medical expenses and future financial loss. This is a claim that in common law courts could easily tick over $1 million. I think that's sort of worth knowing, isn't it? And the other part is, of course, they can bring claims in discrimination tribunal. Once again, in discrimination, not a hard claim to mount. It was brought under the federal legislation. There's opportunities to get costs and leverage in it as well. Again, probably a claim of close to $400,000 to $500,000. So if you're a gambling person, you do common law court. If you just wanted safety, you'd go through the Fair Work Commission and Federal Court and General Protections. You'd probably end up with $300,000 to $400,000. Discrimination about $500,000, but up to $1 million for repudiation. Do you see how big this issue is? So why are we talking about this? How often do people regularly pay Christmas bonuses, or other bonuses, and say purely discretionary? But every year people budget for it. And every year there's discussions about, yeah, look, we're having not a bad year, no problems this year, and people keep saying and doing it. Can you just understand what is the impact? Now, the last part of this is, Goran said in 2024, when she was thinking of going to Auckland, New Zealand, look, we're having a great year. You could earn more than $300,000. So, was that a representation made by Goran? Absolutely. At the time of making that representation, was the representation untrue? Well, based on what he subsequently said about the problems in the business, it would be deemed to be untrue. Did she rely upon that? Yes, she did. You're seeing where we're going now? Did she rely upon it to a detriment? In other words, has she suffered loss as a result of it? Yes, she has. So under competition law, she's got a misleading and deceptive conduct claim. Now, what sort of damages would be in that? Well, this is a really interesting case because competition cases, particularly when they look at losses, again, look at predictive loss going forward in the future. So you mightn't have the same general damages benefit you have, but her loss of the role at Opal, you may be able to demonstrate that there is a loss of opportunity for future roles at the same level by her loss of job, her mental health issues that happen, failure to be re-employed. All those things means not only would she have the lost earnings she had at a current level, but with the expectation that over time that would go up, she's missed that opportunity. So again, that risk is very real and again is at least as much in damages as a discrimination claim. And if you rolled that into the common law claim, it would broaden and deepen that common law claim. So your claim may go well over $1 million. So interesting set of facts to note. I'm really pleased the young guys all got together in the team and put this all together for me because I've been out studying actually. I've been out doing work, learning new tricks so that we can do much more facilitation and mediative work as a business for businesses. And I'm quite excited by what I've been doing over the last 4 to 5 weeks. But to my team, thank you very much. And to all of you, I think we just move on to our last slide now, which is to say thank you very much. And can you give me a bit of a thumbs up? And we'll see you next week. Cheers.